Advocacy is now in session.
Before Mr. Hibner calls the case, just a brief reminder to council that while we don't anticipate any technology-related problems, we might have something. If we do, everybody just take a deep breath and pause, and our experts will work us all through it. Mr. Hibner, call the case, please.
The City of Cleveland versus the Health Services and Development Agency, State of Tennessee, et al.
We'll hear from the appellant.
Thank you, Your Honor. I'm Doug Johnston of the Nashville Bar on behalf of the City of Cleveland. We have raised two issues for this court. They are separate, but they are intertwined as well. The first is, did the trial court err in dismissing this complaint on a Rule 12026 motion to dismiss when the plaintiff here, the City of Cleveland, can prove a set of facts that could entitle it to relief? And then the second issue is whether the trial court erred in misinterpreting TCA 6811 1607 C9A so as to render the phrase return receipt requested as mere surplusage. Now, I imagine that the first question that this court or any court would want to know the answer to is this: doesn't the statute in question, that is TCA 6811 1607 C9A, simply require that the specified notice be mailed? And the answer to that question is clearly yes. But that's with several caveats, and I want to go through at least four of those caveats or qualifiers. The first is that the statute itself specifies a specific manner in which that notice is to be mailed. It is not merely mailed. It is not mailed by certified mail. It is mailed by certified mail, return receipt requested. We can prove, as we have shown, this is already in the record before this court, that there is a difference between certified mail and certified mail return receipt requested. We can prove that by no less of an authority than the U.S. Postal Service itself. And it is important that the legislature used the term certified mail return receipt requested. The second caveat is that here there is no modifying language or qualifying language as can be found in other statutes, and I'll discuss that in just a little bit, which would temper that requirement of certified mail return receipt requested. Third, in this case, there is a clear and, for the purposes of this motion, undisputed allegation that notice was never received and that the City of Cleveland was prejudiced thereby.
Counsel, let me just kind of go right to the question you ever wondered, but is there any dispute whether or not it was sent? I understand the dispute about whether or not Cleveland received it. Is there any dispute that it was sent by certified mail return receipt requested?
Well, Your Honor, we haven't gotten there yet. The motion to dismiss necessarily takes the complaint as it is, not as the parties or a court may wish it to be. The issue of whether it was mailed is addressed in three different paragraphs in the petition: paragraph 13, 14, and 15. In each one of those, the only thing that is alleged is that it was purportedly sent. That is, all we're saying is that the respondent, MTTC, says that they sent it. not that it was actually sent. That's what we have in the complaint before us. And really, that is the fourth caveat that I wanted to discuss. There isn't any allegation in this complaint, which is all we have before us at the moment, that the notice was in fact mailed. Now, before I discuss each one of these, I want to briefly talk about the case of Arden versus Kozawa, which we've relied upon, and specifically we've relied upon the reasoning. Arden is found at 466 Southwest 3rd, 758, was decided by the Tennessee Supreme Court on June 30th of 2015. It's a healthcare liability case. The issue there was the method of providing pre-suit notice to potential defendants. The statute requires that notice be mailed by certified mail, return receipt requested. But there, the plaintiff's attorney sent the notices by FedEx instead. The defendants actually received those notices, and there was never any allegation that they were prejudiced by the method of sending. Suit was filed within the time period as extended by the statute, and the trial court then granted a motion for summary judgment on statute of limitations grounds, finding that the plaintiff could not rely on the extension since the notice did not comply strictly with the statute. The Supreme Court reversed. It first noted that there was no allegation of non-receipt or of prejudice. And because of that, only substantial compliance was required or was necessary. But here's the important part. The court noted on several occasions, and I'm going to quote here, the overarching purpose is to ensure that the defendants receive timely notice. The court also noted in there that FedEx had tracking capability, that the notices were tracked, and that proof of receipt was filed with the complaint. And the court emphasized on several points in there that the legislative intent was that the potential defendants actually receive that notice. So applying that reasoning here, the overarching purpose of this statute, TCA 6811 1607 C9A, is that the specifically enumerated elected officials actually receive notice of an application for a certificate of need. It's important to note, I think, here that this procedure is only triggered when the certificate of need application is for what's called a non-residential substitution-based treatment center for opiate addiction. So it's a very narrow subset of certificate of need applications. But that didn't happen here because the notice was never received. What we are required to do is to presume that the legislature knew and understood exactly what it was doing when it used the term certified mail return receipt requested. As we can prove to the court, certified mail only provides proof of mailing. Certified mail return receipt requested provides proof of both mailing and of receipt. Therefore, if you are proving, and you have to prove that you have sent something certified mail return receipt requested, it is important that you provide both proof of mailing and proof of receipt. As we found, as I discussed here earlier or mentioned, there's no modifying.
I'm sorry, let me interrupt you again. But the statute, what the statute says is that they shall send a notice by certified mail return receipt requested. I mean, yes. That's the language in the statute.
Yes.
I mean, are you asking us to add return receipt requested and the return receipt requested must be returned?
What I'm saying is I'm not asking the court to add anything. What I'm asking the court to do is to interpret this statute to provide meaning to each and every word that is included. And the fact that the statute specifically requires that this mailing be done, certified mail, return receipt requested, has importance. It means that when you submit proof that you have done what the statute requires, you have to prove that not only you mailed it that way, but that it was received, because that's what certified mail return receipt requested is. I see that my time is up. If you have no more questions, I'll wait till rebuttal to respond to anything.
Thank you, counsel. You have your time for rebuttal.
Thank you.
We're here from the appellees, and I understand you've divided your time.
Yes, Your Honor. This is Sue Sheldon. Good morning. From the Attorney General's office, representing the Health Services and Development Agency. The HSDA makes two alternative arguments and requests from this court. The first request is that the court reverse the Chancery Court's threshold ruling that it had subject matter jurisdiction to consider the declaratory judgment action brought by the city. In the alternative, if this court determines that the Chancery Court did have subject matter jurisdiction, then it should affirm the ruling of dismissal for failure to state a claim. The Chancery Court lacked subject matter jurisdiction over the declaratory judgment action because the city did not timely file a prerequisite petition for declaratory order with the agency. In order to confer jurisdiction on the Chancery Court, a petitioner for declaratory judgment under TCA 45225 must demonstrate first that it filed a petition for declaratory order with the agency and that the agency refused to take up that petition. In this case, because an agency rule required that a declaratory order petition be filed at no more than 30 days after the agency meeting at which it considered the project in question. And in this case, the city did not comply with that 30-day deadline, filing its petition 7 days late. As a result, that petition was time barred. And because it was time barred, the city effectively failed to file the petition for declaratory order that is required as a prerequisite to the declaratory judgment action. In the alternative, however, even if the Chancery Court had subject matter jurisdiction,
let me ask you a question, counsel. Let me ask you a question before we leave that. If we agree with Mr. Johnston that the return receipt requested requires, in effect, that the return receipt requested be returned, showing it was delivered, and that didn't happen, does that impact your argument as to subject matter jurisdiction?
No, Your Honor, I don't think it does. The petition for declaratory order was required to have been filed within 30 days of the determination on the application. And the city concedes that it was aware that the application had been granted well within the the 30-day period in which it had the ability to file its action.
Okay.
Even if the Chancery Court had subject matter jurisdiction, it failed to state a claim upon which relief can be granted. That is because the plain language of the statutory notice requirement requires that the notice be sent via certified mail, return receipt requested. That, as found by the Chancery Court, the statute does not also require that the CON applicant provide proof of receipt. While the city urged the Chancery Court and urges this court to include a receipt demonstration requirement, doing so would be inconsistent with the plain meaning of the statute.
Well, what do you think was the intention of the General Assembly in requiring certified mail, not just certified mail, but certified mail return receipt requested? What was we're supposed to determine the intention of the General Assembly. So what was the intention?
There's no reasoned difference, Your Honor, I would suggest, between a certified mail requirement and a certified mail return receipt requirement. The return receipt merely documents the receipt by the recipient. It would be helpful as a piece of evidence in addition to the record of obtaining certified mail, but it does not in and of itself change the clear language of the statute and the use of the verbs, the action verb being limited to send in the statutory language.
But why did the General Assembly include the language? If it's the same effect as certified mail, why did they include the language? We're supposed to give effect to every word there. Why did they include the language return receipt requested? If it's immaterial whether or not the return receipt requested is returned.
I would suggest that the normal usage and understanding of use of certified mail includes a return receipt. It is the layman's understanding and lawyer's understanding of a certified mail requirement is that, again, it includes return receipt. But I don't think there is any reasoned distinction between just using certified mail and going ahead and expounding on it with the additional language of return receipt requested. Because the city's petition for declaratory judgment failed to allege that CCTC had not sent the required notice or not required proof of compliance, it failed to state a claim for non-compliance with the statute, and the Chancery Court properly dismissed it. This court should affirm this judgment. If the court has no further questions, I will stand down and would ask that any remaining time I have be yielded to Mr. Halou.
Thank you, counsel. I think it's about 8 seconds, so we'll keep it to 7:30. Go ahead, counsel. We'll hear from you.
Thank you, Your Honor. My name is Will Halou, and I'm here representing CCTC, the intervenor. I only wanted to make 2 points and then address some of the questions that the court has already asked. The first point is I want us to be careful about what this action really is. Is it the appeal of the grant of a certificate of need, or is it a DEC action seeking review of the department's decision not to revoke a certificate of need? The reason I think that's important is because those two things require looking at two very different sets of facts. If it is the appeal of the grant of a certificate of need, I want to start by saying that there are two statutory requirements that must be met. The entity or person appealing must have objected to the application, and the appeal must be filed with the department within 15 days of the grant of the application. Now, let's be clear. These are requirements implemented by the General Assembly, not by the rulemaking process of the department. I did want to say there was a question asked about whether the lack of receipt, and I think what it was getting at, would somehow toll that limitations period. And I agree with General Sheldon's argument, but I want to add to it. These meetings, they're noticed and they're public. There's an agenda that is included when the meeting is noticed. That agenda included this CON. The petition itself states that the city was generally aware of the application. Even if there is a tolling argument, and we don't think there is, any reasonable person generally aware of the application, through reasonable investigation by checking these notices in the public records, would have known. And they would have had 15 days to file that appeal. They didn't. And so, Your Honor, we think that deprives the court of subject matter jurisdiction. Now, if it's a declaratory judgment action seeking review of the department's decision not to revoke the CON, that review is limited to the statutorily enumerated reasons for revocation. Only one of those reasons is cited here, and that is providing misleading, false, or incorrect information in the application. The only thing CCTC provided in the application was a blank return receipt addressed to the mayor. There is no argument that that is false, that that is misleading, or that that is incorrect.
Was a later, counsel, let me ask you on that, was there a different return receipt requested, presented to the court somewhere in here that was signed by, I believe it was a M. Lane?
Yes, Your Honor, I'm going to travel with you a bit outside the record if you'll allow, because I think I have to. But as part of our motion to intervene, we did include the receipt you're talking about. That receipt, M. Lane, it appears, is an agent of the United States Postal Service. And during COVID, because at the beginning we weren't sure if touching things or not touching things was okay, USPS implemented a policy that the delivery person would sign the receipt and just hand the mail off. And so that's
not in the record, right? So we don't really know.
It's not. I'll say this: it is.
We don't know anything unless it's in the record.
What is in the record is the signed receipt. What is it's even referred to by the appellants in their brief, and so there is no argument. And Mr. Johnson was clever in how he stated it. You asked if there was a dispute as to whether or not the notice was sent. There's no good faith dispute. This idea that the word purported does not equal we're saying it was sent, that's not the standard that the court should use. If they allege it wasn't sent, they need to allege it.
The trial court certainly found it was sent by certified mail, return receipt requested, correct?
Yes, Your Honor.
No dispute on that.
No, Your Honor. The last point I wanted to leave this court with is that, and also I want to defer to General Sheldon's argument on the 30-day rule for deck actions. The Supreme Court in Nunn v. the Tennessee Department of Corrections had a great quote, and it said, for a declaratory judgment action, the appropriate statute of limitations depends on the nature of the substantive claims sought to be asserted. A declaratory judgment action is time barred if relief on the direct claim would also be barred. A contrary rule would allow the plaintiff to make a mockery of the statute of limitations by simple expediency of creative labeling. I mention this to say the petition is seeking, it states that the CON was, quote, improvidently granted. It is an appeal of the grant of that CON. The creative labeling of a deck action does not extend the 15-day period to 10 years. And if you look at why that probably should be the case, when a CON is granted, facilities are built, people are hired, money is spent. It can't possibly be that these petitioners then have 10 years to come back and say, none of that should have happened. You've wasted your money, take their CON away. It shouldn't have been granted. That's why we have these short limitations periods. So, Your Honor, moving on from that first point of we need to be careful of what this is. Is it an appeal or is it a deck action for revocation? I want to get to the actual substance. And I think the court had it surrounded, judging by the questions it asked. And it is clear that the CON notice statute only says that the notice shall be sent by certified mail return receipt requested. That's it. Doesn't say anything about submitting proof of receipt. And quoting the Supreme Court in Re Estate of Tanner, when a statute is clear, we apply the plain meaning without complicating the task. That's it.
Why did the General, again, I'll ask you the same question I asked General Sheldon. Why did the General Assembly include the language return receipt requested? I mean, it adds nothing to just being certified mail, doesn't it? If you're requiring a return receipt the return receipt requested be returned.
Agreed, Your Honor. And I do think that the General Assembly knew what they were doing here. The reason it is asked to be sent return receipt requested is because as part of the application, the applicant must submit proof of sending. And the General Assembly decided the simplest, easiest way to do that is the return receipt card. And so they asked that it be sent return receipt requested. It's important to note that the General Assembly knows how to require proof of receipt. It did it in the Rules of Civil Procedure when it states when a complaint is filed, the plaintiff must provide proof of receipt when it files the return of summons. It chose not to do that here. And Your Honor, I see my time is up. I'm happy to answer any other questions the court may have.
I hear none. So we'll hear from the appellant in rebuttal, Mr. Johnston.
Thank you, Your Honor. Let me respond to that very last thing first. Certified mail, as we know from no less an authority than the U.S. Postal Service, provides proof of mailing. So if the legislature only intended that proof of mailing was enough, then they could have said and should have said that the notice could be sent by certified mail alone, but they did not. They added the additional thing, return receipt requested, which also, according to the U.S. Postal Service, then provides proof of receipt. That is the crucial difference. We can prove that, and if we can prove that, then I believe that that should entitle the city of Cleveland to some relief. Let me briefly address this issue of subject matter jurisdiction. Subject matter jurisdiction is conferred upon any court either by constitution or by statute, period. The statute here requires one thing and one thing only, and that is that the petitioner have previously filed a petition for a declaratory order with the agency involved. That was done. There's no dispute at all that that was not done. So the statutory requirement has been met. We have to kind of think about this in using what we know actually happened here. The mayor of Cleveland never received this notice. He did not know that the certificate of need application had been filed, and he did not know that the agency was having a hearing in August. And because he didn't know that at the time, he didn't appear. He didn't know it when they granted it. They didn't find out about this until sometime afterward. What the respondents want to do here is to graft an executive branch rule onto this issue of jurisdiction and therefore prevent, in this situation in which the city was not notified until too late, and keep the city out of court at all. I want to reiterate something I said a little bit earlier because I think it's important. This particular method of service is only in the situation where the particular CON is for this non-residential substitution-based opiate treatment, opioid addiction treatment center. That's it. That's the only kind. And that's because the legislature recognized that this particular kind of facility is very controversial. And so it gave a number of elected officials the opportunity to be notified and to appear, if they wish to either give their blessing to it or to oppose it. But that did not occur here because the city did not ever receive its notice.
Council, let me quickly, the opposing council talked about whether this was a deck action or appeal of the agency action. Which is it?
Well, it's clearly a declaratory judgment action.
Okay. You're proceeding then as a declaratory judgment. Okay.
Absolutely. I mean, what they want to do is rewrite my complaint so that they can then say, gosh, you didn't follow all of the rules, but that's not what this is. This is clearly a declaratory judgment action.
All right.
I do want one last thing that in my last 20 seconds here, I want to point out, I think the court has already seen this, but what basically the state is arguing here is that there is no difference between certified mail and certified mail return receipt requested, and that the phrase return receipt requested in this statute has no meaning. With that, my time is up. Thank you, Your Honor.
Court thanks all counsel on this. We appreciate your oral argument this morning and your brief. I believe you've made the issues and your client's respective positions on them very clear. So thank you for that. Mr. Hebner, if you'll please recess court till our next case.
This honorable court is now in recess until